motion around bond. It takes them about 5 minutes to read it and then deny it. Where was it?
Is that right in the front?
Oh, we walked by it.
Thank you. Thank you.
We walked by it. I didn't see it.
No, thank you.
Anybody doesn't have a CLE form to use one?
Well, good morning. We should probably get started. Welcome. Thanks for coming for what is, I guess, a kind of a timely talk about stare decisis and precedent in the U.S. Supreme Court. For those that don't know me, I'm Jonathan Adler. I'm the Johann Verhoeven Memorial Professor of Law here at the law school, and I direct the Environmental Law Center. And I'm going to, over the next, I guess it's an hour because you all want your CLE credit, talk about the past, present, and future of precedent in the U.S. Supreme Court. So here's our court, although here's what it looks like now, with fences and barricades in front of it, perhaps related to this subject because, as we all know, earlier this year, the Supreme Court overturned a 50-year-old precedent, or 49-year-old precedent, Roe versus Wade, in a case called Dobbs versus Jackson Women's Health Organization. In this case, has certainly prompted a lot of discussion about the practice of adhering to precedent, when courts do adhere to precedent, when they don't, why they adhere to precedent, why they perhaps should, and when they shouldn't. And so what I plan on doing over the next 45 minutes or so, because I want to leave time for questions, is talk about the idea of precedent and how it's been treated by the Supreme Court and how to understand how the court approaches precedent and perhaps give a sense of what we might want to think about that. So as mentioned in Dobbs, there we go, the court concluded that Roe and Casey versus overruled. The court was very explicit about this. 5 justices on the court thought that Roe and Casey should be overturned. 4 did not. The idea of stare decisis, we've all heard it. I'm not going to pronounce the Latin because I never took Latin in high school, and I'd mangle it. But the phrase from which stare decisis comes from means that it is the principle to stand by things decided and not disturb settled points. The idea that when certain questions of law have been determined, we should follow them, we should adhere to them, we should rely upon them, we should recognize that they are settled. And the idea that this would be part of what the courts do, that the nature of the judicial power in Article 3 of the Constitution would include recognition of precedent was not a controversial idea at the time of the founding. Courts were primarily common law courts. There were also obviously courts of equity, but the idea that the courts would be bound by strict rules and precedents was not controversial. In fact, it was one of the reasons why Alexander Hamilton wrote in the Federalist about how the judicial power is one of judgment and not of will, because the judicial decision making is corralled by, is constrained by various rules and as well by the notion of precedent. Importance of stare decisis. This is a misleading slide because while that is then Judge Gorsuch standing at this podium, the quote is not from that speech. It's from a different speech that was included in his book. But as he put it, precedent is a way of accumulating and passing down the learning of past generations, a font of established wisdom, richer than what can be found in any single judge or panel of judges. A judicial decision that stands the test of time, that is applied in multiple circumstances, that is perhaps modified or curated over time, itself embodies wisdom of many judges over much time. This is part of the rationale for a common law system, that each individual decision is certainly a judge or a panel of judges' attempt to reach the correct answer in that case, but the accumulation of decisions over time embodies a broader and richer accumulation of knowledge than any single decision can. And judges, when they rely upon precedent, are drawing upon that wisdom. They're drawing upon the fact that lots of really smart people in lots of controversies have thought about these questions. And if those decisions have coalesced around a certain set of outcomes, then that is something that should be given a great amount of respect and consideration. What are some of the ideas here? Well, it protects reliance interests. What is one of the functions of the law? Well, it helps us understand who has a right to what our various obligations are. And we make plans, we make investments, we enter into arrangements with each other based upon an understanding of what the rules are. Of if there's a dispute, how is that dispute going to be resolved? And those sorts of reliance interests are pervasive in any modern society. And stare decisis helps protect those reliance interests by assuring people that there's a certain amount of stability in the rules against which they order their affairs. It has an economic efficiency justification in that it reduces the incentive to challenge or relitigate settled questions. In each case, you don't have to go back to first principles. You don't have to go back to ground zero and figure out every question that leads up to the precise thing before the court at that time. You can recognize that all sorts of predicates have been already determined. And you can rely upon that. And you can just then focus on, okay, how do those prior decisions, those prior resolutions apply to this particular circumstance? Does the case applying to cars also apply to boats, as opposed to going all the way back to whether something relates to vehicles or contrivances or like in the first place? It fosters even-handed decision-making, the idea that we should decide like cases alike, that equal justice under law requires treating decisions or reaching the same decisions in equivalent circumstances. And stare decisis in many of its forms certainly fosters that as well. It restrains judicial hubris. Judges are smart people. They may sometimes think they know more about what the principles should be than they really do. It constrains any incentive a judge might have to try and just solve things the way the judge thinks is best, because stare decisis is part of the range of rules that constrain the sorts of things judges can decide in a given case. And insofar as we are ever worried about judges doing too much, usurping the role of the legislature perhaps, stare decisis helps constrain judges in that respect as well. And certainly some would argue it also fosters judicial legitimacy, because it helps us see judges and the courts as distinct from other political actors, as being bound by rule of law-based constraints that members of Congress, that members of the executive branch may not be bound by. That whereas elected politicians may be able to make ad hoc judgments about what policy should look like, that legal principles embodied in precedents prevent judges from doing that, and presumably that gives judges some degree of legitimacy that for the role that they play, including the exercise of judicial review of decisions made by the political branches. But, always a but, Jonathan Swift said, not so much of a fan of stare decisis, and I apologize for that typo. It is a maxim among those lawyers that whatever, it should be two typos. This is a slide I added literally 10 minutes ago because I found the quote, and I'm like, oh, I got to throw this in. And I should have double-checked it. So it is a maxim among those lawyers that whatever hath been done before may legally be done again, and therefore they take special care to record all the decisions formerly made against common justice and the general reason of mankind. You got away with it once, you get away with it again. We could expect this sort of sentiment from Jonathan Swift as a satirist, but it is a notion that stare decisis, while it promotes all of these concerns that I noted, there is a potential downside, because courts might make mistakes. They might get it wrong, and if that is then binding, well, then we might be stuck with it. And that is why Justice Alito wrote, although we approach the reconsideration of our decisions with the utmost caution, stare decisis is not an inexorable command. But this is not from the Dobbs decision. This is not from last term. This is from a case called Pearson versus Kellyanne in 2009 that was unanimous. So all the justices accept that while stare decisis is important, while precedent matters, it's not inviolate. That we need to be careful about when we overturn it and when we reconsider it, but it is something that at times must be abrogated. There are times when precedents have to be overruled. And again, every justice, with the exception of Justice Jackson, because she hasn't decided any cases yet on the court, but every current justice on the Supreme Court has voted to overturn a precedent since they've been on the court. This is hard to see, but this is the number of decisions overturning prior precedents per term going back to the nation's founding, and we see it happens a lot more in the 20th century than it did in the 19th and in the late 18th. That should not be surprising. The numbers alone would suggest some sort of trend in that direction. The more decisions there are to review, the more decisions there may be that need to be overturned. Assume a constant error rate by the court. At some point over time, the court will overturn more decisions because there will be more to overturn. The first case, Hudson versus Gustier in 1810. This was a case involving jurisdiction over ships captured by privateers in foreign ports. I should get Dean Scharf to come down because it's this international law thing that's totally out of my bailiwick. But it overturned a case that had been decided 2 years before. The great Chief Justice John Marshall dissented. He did not think the case should be overturned. But 1810, the first time the U.S. Supreme Court overturned one of its own precedents, and it was a relatively new one, over what at the time was a relatively important question. We cared a lot about questions about when courts had jurisdiction over who owned what ships and whether it was piracy and who had owned the goods on the ships and stuff. That was an important sort of question at the time. And overturning that, folks may be familiar with, one of the more famous relatively quick overturnings in our nation's history. In Minersville School District versus Gabitus in 1940, Supreme Court held that it was permissible to require students to stand and salute the flag and say the Pledge of Allegiance. It was an 8-1 decision. About 2.5 years later, Justice Robert Jackson wrote the majority opinion in West Virginia versus Barnett, saying that no, that was unconstitutional. This is one of Justice Jackson's most famous opinions. There's some famous quotes from it about how our constitutional order does not accept the idea that one can be forced to articulate a creed that they do not believe. So there had been some change in the court's composition. There were 2 justices that were part of the West Virginia Barnett decision that had not been part of the Gabitus decision, but if you do the math, that doesn't quite get you the flip. A couple of the justices changed their mind. And in 2 years, in a little over 2 years' time, about whether or not students could be required to stand and salute the flag and say the Pledge of Allegiance in a public school. There are lots of examples. Here are just a handful of fairly big ones, cases and subjects that I think people are familiar with. A West Coast Hotel versus Parish, the part of the famous New Deal switch in the court, overturning Atkins versus Children's Hospital, and by implication and extension, Lochner versus New York, holding that regulations of economic liberty, infringements on the right to contract would not be subject to any sort of heightened scrutiny, and that governments could, for example, set minimum wage and maximum hour laws. Brown versus Board of Education overturning Plessy versus Ferguson, a 58-year-old precedent at the time, one of the older precedents to be overturned by a Supreme Court decision. I don't think I need to remind folks of what that was about. Atkins versus Virginia, on whether or not it's permissible under the 8th Amendment to execute somebody who is mentally impaired. That was 2002. That overturned a 13-year precedent. Two more recent ones, Lawrence versus Texas overturning Bowers versus Hardwick, Obergefell versus Hodges overturning Baker versus Nelson. Lawrence, of course, holding that states could not prohibit sexual activity between consenting adults. Obergefell versus Hodges holding that states could not treat same-sex marriage differently than opposite-sex marriage. So we overturned precedent a fair amount, and we've done it in quite a few high-profile cases. That leads to some difficult questions about, well, when should we do it? And why? There are a bunch of factors that are often pointed to. The nature of, about whether or not to overturn a case that was wrong. And so, of course, the first step, presumably, is that the case was wrong. I hope we wouldn't overturn a case that was right. Now, we may not agree on which cases were right, but presumably, we would expect a judge to first conclude that a case was wrong. But that's not enough, or that's generally considered to be not enough. Most judges, most justices do not think that's enough. So one question is the nature of the error. And one of the big factors here tends to be, is this an error related to a constitutional principle, or is it something related to the common law or the interpretation of a statute? And one reason, since you're all alums, I'm resisting the urge to call on people about why that might be. So I'll just explain. But I have at least one student in the room, and every time I see him, I'm like, oh, I can call him Mr. Kaufman. But I won't do that. So one issue is the nature of it. So one reason for that is that if the court misinterprets a statute, Congress can fix it. It's not easy for Congress to fix it, but Congress certainly has the ability to do so. If the court makes an error about the common law, the legislature can fix that as well, because the legislature can abrogate the common law. And so the error costs of those sorts of errors are relatively low, at least in comparison to constitutional errors. Because if the Supreme Court makes a constitutional error, there are only two ways to fix that. One is a constitutional amendment, and unlike enacting a statute, that's really, really hard. We've done it 27 times in total, but it's really, we've only done it in about 14 or 15 periods of time, because some amendments were enacted together, like the Bill of Rights. So that's really hard to do. So the only other way to correct a constitutional error is for the court to correct it. So one factor is certainly just what type of error are we talking about? We often think about the quality of the reasoning. To what extent was this a reasonable error, a question that we might think is open to dispute? To what extent is it rest on premises that are broadly accepted or not? Concern for the workability of the result, right? Sometimes a decision in the abstract seems like it makes perfect sense. And then trial court judges try and actually apply it. And they're like, what did you do? How do we do this? And there are lots of examples of this sort of thing. And there are probably lots of examples in part because, I guess as of this year, there are two Supreme Court justices currently on the court that have experience as being trial court judges, Justices Sotomayor and Justice Jackson. But certainly in recent decades, the amount of experience understanding how you take this broad principle announced by an appellate court and apply it in the context of administering a trial that's not been the sort of experience we've had a lot of on the court in recent years. And so hopefully eventually, if a rule doesn't work, that's something you look at. Well, this may have, so maybe a decision was wrong in the first place, but if it creates a clear rule that's easy to apply, it's understandable why the court reached that judgment. Maybe that's the sort of decision you leave alone. Whereas if it's producing a lot of divergent opinions, trial courts are having a hard time applying that principle in a consistent manner, well then that would be on the side of, let's fix this. The other factor is kind of the extent to which the precedent is disruptive. And what the court usually means by this is the extent to which the error or the problem is confined to the subject matter or the precise question in which the case arose, or whether or not it bleeds into other areas, whether or not it embodies principles that, if they are applied more broadly, would kind of spread the error. And then reliance interests. To what extent, as we talked about already, do people plan their affairs, enter into contracts, buy property, engage in arrangements, whatever else, based on the law being a particular way? Now we can list these factors, and there is fairly broad consensus that these are the dominant factors. If you read the opinions in Dobbs, both the majority and the dissent identify these 5 factors as all being important. As might not surprise you, the majority and dissent do not agree on how any of these factors applied in Dobbs. Some of that relates to the underlying disagreement about whether Roe and Casey were correctly decided in the first place. And some of it relates to what the nature of the inquiry should be. So, for example, if one looks at reliance interests, the majority takes a very, for lack of a better word, old-fashioned view of reliance interests as primarily being concerned with property and financial relationships and contracts and those sorts of things, whereas the dissent's view of reliance interest is broader and thinking more about the way people think about planning their lives and, in particular, for example, planning reproductive decisions. So we can identify these factors, but these factors do not, these are not a formula. They're not something upon which reasonable judges and justices are going to necessarily agree, certainly in certain sorts of circumstances, but these are at least the grounds upon which the discussion takes place. Right? These are the sorts of issues one is going to point to and the arguments that one will make and raise. I said that most justices agree with this because Justice Thomas takes a different view, and it's a long-standing view. This quote is not from Dobbs because he didn't, while he wrote a dissent in Dobbs, a concurrence in Dobbs, he didn't feel the need to go back through this point. But his argument, or his belief, is that if a prior constitutional opinion is demonstrably erroneous, in his view not a permissible interpretation of the text, the court should correct the error regardless of whether other factors support overruling the precedent. Demonstrably incorrect judicial decision is tantamount to making law, and adhering to it both disregards the supremacy of the Constitution and perpetuates a usurpation of the legislative power. And while he's the only justice, as far as we are aware, that has this view of the current justices, it is worth pausing a little bit just as understanding what this claim is. It's an aggressive claim, to be sure. But the claim is based on the premise that justices take an oath to uphold the Constitution, not an oath to prior decisions of the court, and that if a decision is contrary to the Constitution and it is presented to the court, the oath obligates the justices to decide the case in light of what the Constitution requires, not in light of what prior precedent would hold. There are some caveats. I mean, it has to have been properly raised. It has to be probably before the court and so on. It's not just freewheeling. Oh wait, there's some case in footnote 4 of your brief, and I think that's wrong. So, have at it. And so Justice Thomas is actually somewhat notorious for authoring concurrences that say something to the effect of, while no party raised it, I would be happy to consider whether we should overrule such and such case from 1823 or whatever. But this is, certainly among academics, this is a very serious view. And it's premised on this idea, at least with regard to constitutional error, that if one accepts the premise that the meaning of the Constitution is fixed at the time of its ratification, which is itself a contestable premise, but one that Justice Thomas adheres to, and that's what a justice's oath is to, then when asked to reconsider a precedent, the court must base its decision on what the Constitution provides, and that if there is to be some other accommodation, because other sorts of factors, prudentially or otherwise, counsel doing something else, well, those are the sorts of things that legislators are supposed to do, not the sort of thing that judges are supposed to do. And this view is certainly tied to the fact to Justice Thomas's originalism. He is, as I think folks know, an avowed originalist, and arguably for in his time on the court, has been the most originalist justice in his time on the court. The scholarship that's been done on it suggests that he was even more originalist than Justice Scalia, because there were certain questions Justice Scalia thought were too messy and didn't want the court to consider, like the meaning of the Privileges or Immunities Clause in the 14th Amendment. Scalia was like, yeah, it's a Pandora's box, don't open that. Justice Thomas's view, it's in the Constitution, that's what our oath is to. If it's messy, if it's hard, so be it. So that's again, but that is as of now, as far as we are aware, this is a view of one. But when you read other things that Justice Thomas says about prior precedents, this is where it's coming from. It's coming from this view that how long-standing a precedent has been should not matter. This is some data that was compiled by a guy named Adam Feldman at a website called Empirical SCOTUS, looking at votes in the Roberts Court, how frequently, when given an opportunity to reconsider a precedent, various justices on the court voted in that favor. It's for Justice Gorsuch and Justice Kavanaugh, since they participated in the fewest number of cases in the time period since 2005. This date is 2005 to 2020, or 2005, sorry, 2018. You don't get a lot of, the Gorsuch and Kavanaugh data point aren't very probative. But one of the things it does show is that there is a spectrum. Those 5 factors I pointed out before, that at least that all of the justices during this time period that have served since 2005 believe are important, are applied in different ways. And that Justices Breyer, Sotomayor, and Kagan, for example, have tended to find those factors to weigh against overturning precedent more frequently than, say, Justice Thomas or Justice Kennedy or Justice Alito. We don't really yet know about Justice Barrett and Justice Jackson. The numbers are just, we just don't have enough cases to really say much about their view on this. But part of the point is within these factors, as we already noted, reasonable people may disagree about how they apply, and there is disagreement on the court. Disagreement that appears to be somewhat along right-left lines, although notice that Chief Justice Roberts votes to overturn precedent less often than did Justice Ginsburg. But it is certainly somewhat based on ideological lines. And one reason for that, of course, might simply be, given the personnel on the court during this time period, it's a lot easier to overturn precedent in one direction than the other, right? So we don't know what this data would look like if there was a court with a more liberal majority as opposed to a more conservative majority. And so it's hard to disentangle about whether or not this is purely about views of precedent as opposed to views about what the precedents are that are being that are up for grabs or that are being considered. Here's some data over time. This is precedents altered 1953 to 2020. So from the beginning of the Warren Court to today, there's a Supreme Court database compiled at Washington University at St. Louis. And so this is their data set, looking at the number of cases per term, 1953 to 2020. We can break that down by Chief Justice. These are 3 different measures of overruling, and part of the reason is that sometimes the court is explicit about overruling a case, sometimes it isn't, sometimes it suggests it's overruling a case, sometimes, like we saw last term, the court says, oh, we've already gotten rid of that case, and people are, well, when? In a case called Kennedy, the football coach case, there's a line in Justice Gorsuch's opinion saying, we gave up on the Lemon test a long time ago, but that hadn't been said in a majority opinion. So the blue line is prior cases overturned. The red bars are cases that overturn prior precedents, right? So sometimes an opinion may overturn more than one precedent. Dobbs overturned both Roe and Casey, so it would count once in the red bar, twice in the blue bar. And then the green bar is the data from the prior chart showing adherence to precedent. And as you can see, if we add some trend lines to the 3 data sets, it is interesting that the overall trend is towards overturning precedents less often since 1953. And the court that seems to have been most aggressive in overturning precedents, and this is all per term data, was the Burger Court. A little bit more so than the Warren Court, but that the Rehnquist Court and Roberts Court have, just in terms of numbers. Now, obviously, not all precedents are equal. If the court overturns a precedent about, application of, I'm trying to think of something constitutional and really obscure that won't offend anyone based on their practice area. If one overturns something small about how Article 3's jurisdiction should apply in certain cases, we might not think that's a big deal. If the court overturns a case involving a right protected by the Constitution, we might think that's a very big deal. So obviously this is just numbers, right? This is not about, right? This is not saying good or bad. It's just saying in terms of number of cases that it happens, it declines. The other thing that's worth noting about this is, of course, the number of cases the court takes is also on a downward trend and has been. The court heard a lot more cases during the Warren and Burger courts per term than it does now. Part of that is due to some changes in the court's jurisdiction that were enacted by Congress in the 1980s, and some of that is just the justices just being a lot more stingy about taking cases in the first place. So if we were to do percentage of cases that modify a precedent in each term, you'd actually get some different numbers, because the cases that modify or overturn precedents are a larger and more conspicuous part of the Roberts Court than they were its predecessors. Whoops, I went too fast. So, of course, the real question is, like, what does this mean going forward? And I have some ideas about what this means, and so I'm going to try and share some of that. But of course, the hardest thing about making predictions is knowing the future. And so I'll give you a sense of where I think the court's going in this regard, and what some of the reasons for that would be. So here's what the court looked like in 2016. And so one reason we might think the past might not predict the future is that here's the court today. This is the only court picture of all the justices with Justice Jackson they've released so far. This was at her swearing in. So presumably there will be one of these pictures where they're seated and arranged by seniority eventually, but we don't have it yet. This is what we have. But there's been a significant amount of change. Right? Justice Kennedy replaced by Justice Kavanaugh being a significant change in judicial behavior, I think. Justice Ginsburg being replaced by Justice Barrett, significant change in judicial behavior. I think those two changes on the court for this subject more significant in terms of judicial behavior than replacing Justice Justice Scalia with Justice Gorsuch and Justice Breyer with Justice Jackson, because we believe that those replacements don't represent as significant a change in judicial philosophy as perhaps Kennedy to Kavanaugh, and certainly with regard to replacing Ginsburg with Barrett. On the Kennedy court, or what we called the Kennedy court, or I call the first Roberts court, the dynamic was that Justice Kennedy was the median vote. And it turns out most decisions overturning prior precedents have been 5-4 decisions, in recent years have been 5-4 decisions. Not all of them, but most. That Pearson versus Kellyanne case I mentioned before, that was unanimous, the exception. And if you followed the court when Justice Kennedy was still on it, and you wanted to know what the court was going to do, especially in a 5-4 case, you could really focus on one justice. And about 98% of the time, you would know what the court would do. And so that meant in terms of whether the court was doing things that were liberal or conservative, we could look at the jurisprudence of Justice Kennedy, and we knew that on criminal procedure he was conservative, in federalism he was conservative, in tort litigation he was conservative, and some parts of the First Amendment he was conservative. But on the Eighth Amendment and on notions of individual liberty and war power and as it applies to habeas and other parts of the First Amendment, he was very liberal. And if you look at the pattern of the court's decision in high-profile cases during that period, you see, as Justice Kennedy went, so went the court. And that was also true in overturning precedents. As I showed you before, Justice Kennedy was not particularly bashful among the current justices about overturning precedents. And so when we think about precedents overturned during the Roberts Court, and I've just color-coded these kind of as a sense of as a rough sense of kind of whether we consider these decisions moving the law in a conservative direction or a liberal direction. Kennedy's the majority of all these. He wrote a bunch of them. Right? He's the driving force behind Citizens United. He's the pivotal vote who writes Obergefell versus Hodges. South Dakota versus Wayfair is about dormant commerce clause and taxation on goods from out-of-state companies. So where we saw opinions being overturned during Justice Kennedy, it mattered on Justice Kennedy, and they weren't consistent in one ideological direction or another. By the numbers, he tended to vote more conservatively than liberal just by the numbers, but the cases where he voted in a liberal direction were not kind of minimalist, narrow, small decisions. They were often quite big, as we would see in a lot of death penalty cases, as we would see in cases like Lawrence and Obergefell. Alene versus United States is one of the only cases during the Roberts Court, or the first Roberts Court when Justice Kennedy was the median justice, in which the court overturned a precedent by a 5-4 vote, and Justice Kennedy was in dissent. In that case, Justice Thomas joined the liberal justices, and it related to sentencing matters. And then, in cases where people thought the court might dramatically change precedent, from the whole Women's Health versus Hellerstedt, Justice Kennedy, in the majority, assigned the decision to Justice Breyer. And so when we were thinking about whether or not precedent got altered prior to 2016, or to 2018, we focused on Justice Kennedy. So that's one reason it's hard to get a sense of what will be different. We went at a brief period of time with Justice Kennedy off the court and it being the Roberts Court in the sense of Justice Roberts presumably being the median justice, but it's still a court that we think of as a 5-4 court. So if you were going to overturn a precedent and it was on any kind of ideologically charged question, you would need one of the conservative justices to join the liberal justices, either to overturn a precedent or to prevent the overturning of a precedent. And we would normally expect, or in the modal case, we would expect that to be Chief Justice Roberts who was in play, but we can find examples of all of the conservative justices flipping over in at least one case. In Justice Gorsuch and Thomas's view, there are actually multiple. That was the situation for a couple of years. Of course, that's not the court right now, right? This switch from Ginsburg to Barrett, and yes, that is also at this podium, is more different switch, right? Because that, if anything, produces this. So now the question about whether or not to overturn an opinion in a case where we expect the justices to divide along traditional ideological lines, to either preserve a precedent or overturn a precedent in a liberal direction, the liberal justices need two. And that's a lot harder. I grouped them in threes because it appears that Roberts, Kavanaugh, and Barrett are the most likely justices to switch over in cases where a decision has an ideological valence, although there are exceptions. Justice Gorsuch wrote Bostock, for example. But this appears preliminarily to be what we would see, looking at just not only opinions, but also at orders and decisions on the shadow docket. So it's much harder. Now, there's two possible ways this can play out. Right, one is, I think the easy prediction to make based on this is that insofar as precedents are overturned, they are more likely to be uniform in one direction if we think about them in right-left terms. Right? It's just the numbers to move the law in a quote-unquote liberal direction are just not really there. The harder prediction to make is whether or not the rate at which decisions are overturned, the number of decisions that are overturned, will necessarily increase. Because I already showed you the data that at least, up till now, up through this past term, the Roberts Court is overturning precedents at a significantly lower rate than did the Rehnquist Court, the Berger Court, or Warren Court. And is that because the justices on the court have a particular view of precedent, or is it because they didn't have the votes? Right? And either of those is possible. But it's important to understand that those are kind of two different two different dynamics, right? One is a question of how precedent's being evaluated, the other is being a question of numbers. Some things that kind of relate to this. This is, usually when I give talks about Supreme Court up until 2020, I would show data like this, which is, and I know this is an ugly chart, but so this is by each term, the breakdown of decisions. And what you see for each term is you tend to see a very relatively large dark bar, which is the proportion of decisions that are unanimous. And then you see a smaller number of opinions that are 8-1 or 7-2 or 6-3. And then you see a decent number of decisions that are either 5-4 or what I call 5-4I, which is a 5-4 split on the court where the court is divided along right-left lines, which are usually a significant percentage of the court's 5-4 decisions. And from the first full term with both Roberts and Alito on the court through the 2019-2020 term, we saw relatively stable proportion of decisions being 9-0. Obviously, there being variation term to term, but overall a fairly flat trend line and a declining percentage of the court's decisions being 5-4. That was through 2019. And one thing that we can see, though, in that period of time is that that disguises a little bit what we might think of as the political valence of what's occurring. So the blue bars are conservative majority, red bars are liberal majority. I should have flipped that just because it's easier to. And then green is where there's no real ideological valence. And certainly whether it was Justice Gorsuch replacing Justice Scalia or Justice Kavanaugh replacing Justice Kennedy, it certainly appears that the number of 5-4 decisions in which the outcome is conservative as opposed to liberal does appear to have been increasing in the later years on the Roberts Court. But this is still only through 2019. Oh yeah, there are the trend lines. So we see, if we do that data, we see more conservative 5-4 decisions, fewer liberal 5-4 decisions. Of course, this is all data from a 5-4 court. We don't have the 5-4 court anymore. So if we go take the data through the last two terms, well, one, that trend line that's on that chart, that's the unanimous trend line. So just adding two terms to the data is enough to take that trend line from a flat trend to a pronounced decline. That's significant. The other thing that's significant is I didn't include, for the last two terms, 2020 and 2021, I didn't include the 5-4I bar, in part because the bar that is noticeable in those two terms is the 6-3 outcome. Right, so, the court, since Justice Barrett replaced Justice Ginsburg, is just a very different court in terms of the numbers and in terms of the sorts of decisions that the court makes and the reason for those decisions. And this is just focusing on just since the appointment of Justice Gorsuch, significant decline in percentage of unanimous opinions, and we see the 6-3 line is, I think, easier to see when that's blown up like that. So predicting the future. Not sure. Confident that this is a more conservative court, as we've understood that, what we mean by that when we talk about judges. Confident that the precedents that are in play are those that are precedents that conservative justices have historically been critical of or not liked. And that matters a lot because it's not merely a question of what the justices want to do in a given case. It affects what lower courts do. It affects what sorts of separate concurrence a lower court judge might write. It accepts how aggressively the majority opinion writer on a circuit court might be in a given opinion. It affects what sorts of cases litigants bring. In Dobbs itself, Mississippi, when it first was trying to defend its ban on abortion after 15 weeks, didn't say to the court, well, you'd have to overturn Roe to uphold our law. I mean, most folks accepted that was just, as a matter of logic, you couldn't uphold a ban on abortion prior to viability without overturning precedents that said you couldn't ban abortion prior to viability. But by the time that case got to the court, Mississippi was happy to say, yes, please overturn Roe, and asked it to do so in its briefs. So it's important to remember that the cases the court gets are not merely a function of the cases the court decides to accept. It's also a function of the cases that people bring. Right? Folks that want to further narrow the applicability of the death penalty, or that want to expand certain unenumerated individual rights, are a lot less likely to bring those cases now. They're not in the pipeline. Folks that want to overturn the Chevron doctrine, overturn Humphrey's executor, just to pick two non-random cases from the course I'm teaching this term, right? Those folks are bringing those cases because they think that that might be in play in a way it wouldn't have been a couple years ago. So the court's certainly more able to overturn precedent in a particular direction. It's certainly more able to overturn precedent generally if it wants to because of a 6-3 dynamic as opposed to a 5-4 dynamic. And so then the real question is what the appetite is for overturning precedents. And looking very closely at a handful of cases in the past term or two, I'm really unsure about that because there were cases where the court could have done more and overturned more than it did. And we might have thought the justices would have wanted to do that. So in West Virginia versus EPA, the court could have overturned Arlington, a case called City of Arlington versus FCC. And it would be perhaps obvious for the Chief Justice to do it because he wrote the dissent in Arlington versus FCC, but the court didn't do anything to even cast doubt upon that decision. But if I had to bet, and the bet is, and this prediction is only worth what you paid for, I have to bet that not only are we going to see a court overturning precedents in a more conservative direction, but that number, if we come back in 5 years and I show you that chart again about Warren, Berger, Rehnquist, and Roberts' court, that it might look a little different, and at the very least, we will see a significant difference between what we might call the first Roberts court, the Roberts court up until Kennedy left, and the second Roberts court, or whether the break point should be Kennedy leaving or Barrett joining. We could debate. It would only affect 2 years of data, but I think we will see more. That this court, because of this lineup, will start to overturn precedents more than it has to date, both because there is more agreement on one side of the court, and because simply just in terms of numbers, it will be easier to do. And I think that's my last slide. Thank you for your time and attention. I'm happy to take questions until the top of the hour. And then you'll all have your 1 hour of CLE, and then you'll be free to go. Thank you very much. Questions?
Care to predict in that case arising out of the North Carolina Supreme Court having to do with state authority or state power?
You get a state legislature doctrine case?
Yes.
Okay, so this is a case. I'm going to grossly oversimplify it. The Constitution in 2 provisions says that election rules are supposed to be, or votes are supposed to be tabulated in accordance with laws set by the legislature of the state. And so there's been a dispute that's been growing for some time about whether the reference to the state legislature literally means the legislature or means kind of the political process within the state, or something in between. North Carolina is arguing that insofar as the North Carolina Supreme Court invalidated and replaced or revised election laws in the state, that violated the Constitution because the legislature had made a choice about what the voting rules should be and so on, and the state Supreme Court disagreed. And the state Supreme Court did so on the grounds that it violated the state constitution. And so North Carolina is arguing that, legislature means legislature, can't do this. At least 2 or 3 justices think that at least some version of that argument is correct. If I had to predict, I would say North Carolina will win, but not on the grounds that it's arguing. So North Carolina's position is really aggressive, and would seem to suggest that state courts have no role in considering disputes about the acceptability of legislative rules governing elections. I don't think the court's going to go that far, but it would not surprise me if the court reached a conclusion that says that actually replicates what we have in Ohio right now in our redistricting fight, which is it's one thing for courts to say to the legislature, what you did is wrong. It's something different for the court to actually create new rules in its place, right? So, for example, to draw districts. And so here in Ohio, our redistricting constitutional amendment allows the Supreme Court to review the product of the redistricting commission, does not allow the state Supreme Court to write new districts itself. All it can do is say, go back and do it again. And as folks may know, there's been a lot of that here. It would not surprise me if the Supreme Court said something like that, so that districts could not be drawn by state courts, but election rules could be invalidated by them. I should say there is no conceivable outcome in that case that allows for state legislators after the fact to decide they don't like what happened in an election and just simply substitute their own opinion. The text of the Constitution actually doesn't allow that, because the wording of the text talks about the legislature having to set the rules by which votes were cast, which has always been understood to mean the rules have to be set before the vote, and can't be done retroactively. So I know there's been some popular discussion about the case suggesting that's part of what's on the table. That's not on the table. The question is really just how much, when we're talking about federal elections, does the executive branch and the judicial branch of a state, how much authority do they have to check the actions of the legislature? That's what I think, but we'll know I predict that we will know by July 1st. Yeah.
I was an alum at the management school across the street, so forgive me if the question comes across as a bit late. But when I think back to some of the recent confirmation hearings for justices on the Supreme Court, there is often quite a bit of a big deal made on the line of questioning around stare decisis, and all the justices respond saying, this is precedent, this is what I believe in, and most senators have, that topic that they want to kind of check the box on.
Right.
But my takeaway from your presentation is it doesn't matter.
Yes and no.
It's sort of like it's open to interpretation, and we're willing to hold it if we agree with it, and if we don't, then we should feel free to kind of go back and revisit and relitigate the decision. So why is it such a big deal in these hearings, and is that just a political TV?
Well, yeah, it's political theater, right? So, if you go back and you look at what, every justice has said about precedent in their hearing in the last 30 years, 40 years, going all the way back to Bork. Bork did something different, which is part of why he didn't get confirmed. They say, stare decisis is important, precedent is important, these are the factors, these are the things we have to think about. A precedent is a precedent, all true. None of the justices disagree with that, right? But none of them ever say, therefore it can't be overturned. Certainly about none of the cases that we're talking about. There have been some justices that have been willing to say that about Marbury versus Madison, although Justice Scalia infamously in his confirmation hearing would not even say that about Marbury. Some justices have said that about Brown. But most will not say it about any particular case other than to say it is a precedent. It's a long-standing precedent. It's been reaffirmed. Things that are entirely consistent with when a case is presented to them, looking at it very carefully and deciding whether or not the factors have been met. And when we look at cases outside of something like Dobbs, right, because I didn't spend a lot of time on Dobbs itself, because it's hard to talk about Dobbs without talking about the subject matter and focusing on our opinions about whether we think there is a constitutional right there or not. But we see all these other cases where the court overturns precedent, right? The Wayfair case, right? Overturning a case called Quill. Justices really wrestled with that. Ramos versus Louisiana. Is that the unanimous jury verdict one? Right? Court, I think 6-3 decides that to overturn a precedent about whether jury verdicts have to be unanimous at the state level. If all of the Bill of Rights apply to the states, the answer has to be yes. But like back in the 50s or 60s, the court had said no. And if you read that case, you see all these justices having the same, not all on the same sides, but having that same disagreement you see in the relevant portions of the Dobbs opinion about how do we understand these factors, how do they play out in this case. And so my point there is that, the hearings in that regard are theater. I'm on record wondering why we even have them, because the questioning is usually a mix of insipid or unilluminating or just purely theatrical. And trying to get nominees to say things in a hearing that would require them to recuse should the case they're being asked about actually come before the court is pointless. If you actually want to have meaningful discussions about judicial philosophy, okay, that'd be great, but I'm not convinced many of the senators on the committee are really up for that. Because they want their clip for TikTok or YouTube, right? They don't, or the evening news. They don't, and that's just so. Justices have different views. If I spent the hour talking about the academic literature on precedent, to which Justice Barrett, when she was a law professor, actually contributed to significantly, you'd see these are hard questions. My own view is that the justices have differences of opinion, and it's certainly easier to overturn a precedent you really don't like. And judges are people too, and we know that. But I do think when it comes to it, the arguments you see them making in these sorts of cases, my own view is aren't out of line with what you would expect a jurist to make. Justice Thomas is very consistent on his view. Justice Alito's statements about precedent are very consistent. The cases that he thinks meet his standards are very different from the ones that Justice Kagan thinks meet her standards. But but there are cases where they've agreed. So and I just don't think the type of questioning you get, is this a super precedent? Is it a super duper precedent? That's not probative, right? A question about how do you understand the reliance interest? Is it just money? Is it, a woman's decision to forego child rearing because of where she is in her career or whatever else? Is that the sort of thing that would count as a reliance interest? Well, that would be an interesting question, but that deals with a degree of substance, at least maybe I'm just too cynical, that I just don't expect to see in a Senate hearing. Yeah.
I'm also a business school grad, but I'm married to a professor. Well, one of the ideas you said to do this is to legislate something. Mm-hmm. So when you think about national health and all the uproar of what's caused been going on in the states on Dobbs, what would happen if the U.S. Congress made a national law, let's say about abortion rights, and would the next Congress, I don't know civil law so much, but would the next Congress that might flip the majority, would they be able to overturn that and change that nationally too?
It depends on what the decision rule is, right? So, there's a lot of talk about, right now we have a filibuster in the Senate, and right, to become a law, you need not only, technically a majority in each House of Congress and the president's signature, or you need a supermajority either to get through the procedural requirements or to overturn a presidential veto. And so long as there's a filibuster, then anything Congress does is sticky, right? In the sense that it's hard to undo. If we were to get rid of a filibuster, which is talked about, that would certainly make it easier to have a national law protecting abortion rights. That at least under current precedent, under the Commerce Clause, would pass muster. So that couldn't be struck down without overturning other precedents that have broad effects in other areas of law. But if you got rid of a filibuster to do that, then all folks on the other side would need is a simple majority and control of the White House as well. So, I mean, now, in less high-profile cases, Congress actually corrects the Supreme Court a reasonable amount, and more often than we think. But it tends to be things that are less politically charged. You know, but sure, if Congress did stuff, you know, with legislatures, you potentially have the same sort of problem in that the law can change with election returns, and the things that slow that down tend to be procedural rules. So in Congress, it's things like the filibuster. Within executive branch agencies, it's things like the Administrative Procedure Act, which just make it take a long time to turn a different election result into a different policy. Well, I've kept you guys for an hour, and that's all the CLE you signed up for. So thank you so much for coming. Enjoy your weekend and your reunion.
Thank you.
Thank you.